in this case. The fact is that the court has struck down 2 sections of this legislation. However, the legislation has not been repealed as reported. Prominent attorney at law Gregory Nicholls differentiates between the two.
There's a difference between the mechanics in striking down a law and repealing a law. The courts can strike down any law passed by Parliament or any law that is part of the framework of the statutes of Barbados. The act of repealing is a parliamentary act, where Parliament goes and says we can replace that act with an entirely new piece of legislation or take it out of the whole context of the laws of Barbados altogether.
But he added that it being struck down in court was simply no surprise, as it has been done in Antigua and St. Kitts and Nevis just this year.
One can be really surprised that the courts have struck down the buggery law under Section 9 of the Sexual Offences Act, because one can have seen for a long time that it was on a collision course with the principles under which the Constitution are interpreted, giving dignity to fundamental rights and freedoms under the Constitution. Consensual acts or sexual acts between consenting adults in the privacy of their own home cannot be a situation in which the state would prioritize as needing to criminalize.
And while Nicholls has no issue with buggery being removed from Barbados' constitution, he is awaiting the order from the court.
While I have a challenge with understanding how the act of serious indecency as it relates, particularly to minors, could be part of that process.
He's referring to Section 12, subsection 2 of the Sexual Offences Act, which reads a person who commits an act of serious indecency with or towards a child under the age of 16 or incites the child under that age to such an act with him or another is guilty of an offence and is liable on conviction to imprisonment for a term of 15 years. The implications of this being struck down is that those charged of offences under Sections 9, but more importantly 12.2, cannot be prosecuted. So the primary question is, what are the state's options?
The options for the state are to accept the ruling of the court or to appeal the decision handed down by the court and let the higher courts, the Court of Appeal, and then on to the CCJ as the final court to make a determination as to whether the judge was right or wrong in the whole exercise. The state can also apply to the Court of Appeal for a stay so that persons who are likely to be charged or facing charges right now, the status quo would kind of stay as it is. The government wouldn't press ahead until they get a final ruling on the matter. So you can apply for a stay so that the effect of the law is not necessarily expunged from the books as of the date of the ruling of the court, but it would survive so long as the final appellate court makes a determination on the matter.
The Attorney General of Barbados did express similar concerns with parts of Section 12, and he is awaiting the perfected order and the written decision before considering options.